Mandatory mediation, the Italian experience. ADRs, alternative dispute resolutions, are necessary to save time and money and to have a better life. ADRs are, first of all, a matter of culture, therefore of knowledge and skills. In Italy, mediation was ruled in 2003 for corporate, financial and banking conflicts. It was voluntary. Nobody, Rexius no lawyer, used it. And when I asked why, lawyer replied, because it was not compulsory. According to CPA figures for 2010 and 2012, compared to 46 and 44 other European countries, respectively, Italy had a lower than average portion of the total public spending allocated to the whole justice system, a high number of litigation cases, long-lasting litigation cases, a huge number of lawyers. In Italy, there has also been a shrinking in the litigation market. The number of new civil proceedings has decreased due to the economic crisis which started in 2008, the length of proceedings and the increase in court fees. A decrease of lawyers' revenues. As a consequence, most Italian lawyers read the acronym ADR not as alternative dispute resolution, but as alarming drop in revenues. A tremendous number of pending civil litigious cases in the overall judicial system, with the highest level in 2009, a bit less than 6 million, and a low but steady decrease after death. In Italy, mediation became compulsory in 2010, Law Decree number 28 and Ministry Decree number 180. Facing a furious opposition by lawyers, it was a matter of culture and a matter of revenues, and a benign neglect by judges. It was a matter of culture. Mediation is the procedure, conciliation the result, the agreement. It can only be used for disputes over alienable rights, in Italian, diritti disponibili. Proceedings were to be concluded within 4 months' time. Tax relief was to be provided to the parties involved in the mediation procedure and doubled when the agreement was reached. Legal advisors to the parties were to inform their clients about the mediation process. Mediators, trained according to the law, operated within organizations, in Italian organismi di mediazione, mediation bodies, under the control of the Ministry of Justice. They manage the proceeding without the power to make binding decisions or judgments for the recipients of the service itself. Nevertheless, the neutral can make a written proposal when asked by the parties on his own initiative, and also if one of the parties is missing. Within the following 7 days, the parties are free to accept or decline the proposal. But in the subsequent trial, should the judgment be the same as the refusal proposal, the claimant must pay all judicial costs, including those paid by the losing party. And this is a link with the judicial proceeding. The mediation proceeding must remain secret. The final agreement is enforceable if it does not violate mandatory regulations or if it is not contrary to public policy. And when it's approved upon examination by the President of the Court. Mandatory mediation faced the furious opposition by most lawyers, who, as I already told, were too many and with decreasing revenues. Numerous appeals, and on December 12, 2012, the Constitutional Court declared the unconstitutionality of compulsory mediation due to over-delegation. The government went beyond its power in creating the delegated legislation, and not because of the breach of citizens' right to the funds. Under pressure from the European Union, mandatory mediation was reintroduced, starting on September 20, 2013, with new rules. Proceedings are to be concluded within 3 months' time. Accredited mediation bodies must be chosen within the territorial jurisdiction of the court over which the judge presides. The settlement agreement reached before an accredited mediation body can be enforced either when approved by the court or when undersigned by the lawyers representing the parties. Mediation proceedings are to be concluded within a 3-month time period. And, very important, compulsory lawyers' assistance to the parties, and the first informative meeting free of charge, except for a €48 fee. The mediator works for free. The lawyer hired by the party is paid. The invited party, according to the lawyer misinterpretation, can abstain from the proceeding by not attending the mediation meeting with the plaintiff and the mediator, or present at the first informative meeting can opt out from the process. The behavior of most lawyers has been, and still is, almost a form of boycott. When invited to take part in a mediation proceeding, they refuse to do so. Oftentimes, lawyers attend the first informative meeting without the party they represent, only to declare, "We are not interested in proceeding." The same behavior is adopted by many banks and insurance companies. The result consists in a huge hustle and bustle of paperwork, and up to now, poor results, especially when compared with almost 5 million pending civil litigations. Training can be seen as the Achilles heel of Italian mediation proceedings. 50 hours courses have proved insufficient. At least 200 hours would have been necessary, and they should have been taught not only by law experts, but also by communication experts, psychologists, bankers, etc. ADR are a mixture of very different skills. They need contamination, fusion. On the contrary, in Italy, there is usually no blending of experiences. Lawyers teach lawyers, judges teach judges. The most effective experiences in Italy are those made by universities together with the courts. Theory and practice, not only for students, but also for judges, for whom the mediation is a new technique. It's also necessary that lawyers understand that they can also earn with mediation, especially in times of economic downturn, during which companies need to solve their problems in order to get money. And it's also necessary for the evaluation of judges for career advancement to be based not only on the number of orders issued, but also on the total number of disputes resolved. In Italy, the conflicts subjected to mandatory mediation are only the 8% of all conflicts filed in the Italian courts. Their filing had a 9% increase when mandatory mediation was revoked between October 2012 and September 2013, and a 15% decrease when mandatory mediation was back again. Compulsory mediation would be useful in conflicts related to all disposable rights, separated from the judicial proceedings and with strong tax incentives. Italian judges at the beginning looked at mediation with a benign neglect, because they considered, and still consider, mediation as the child of lesser God. The few who have used the ADR so far have achieved interesting results. They have understood that ADRs are not the solution for all the conflicts, but an additional instrument to achieve a more equitable justice. Since 2010, Italy has become a very interesting laboratory to analyze the consequences of different types of ADRs. And I think we are just at the very beginning.